Hi, everyone. My name is Cooper Knowlton, and I'm joined today with Lee Bergstein. And we're going to be bringing you up to speed on a recent development that happened in New York City related to commercial leasing and personal guarantees. We know this is an issue that many people have been asking us about, and there was a recent decision in the commercial division in New York that may have important ramifications in the world of guarantees.
From the personal liability of typically the principal who had signed a personal guarantee in connection with the lease. And the law basically said that if you defaulted as the tenant during the covered COVID period, which ended up running from March 2020 through June 2021, if you defaulted or there was some other event that gave rise to liability during that period, the personal guarantee, whether it was a good guy guarantee or a full guarantee, was rendered unenforceable. And that's been kind of challenged in a number of ways by landlords. Recently in November, it was challenged in the Southern District. The Southern District said it was enforceable, it wasn't unconstitutional. But now the cases are being litigated in New York State Court. And there was this recent decision in July by Judge Leibovitz, which I think is really important, really notable. A couple of things that we should probably note. This is a very specific factual situation. This tenant actually vacated during the COVID period. A lot of tenants obviously weren't sure what was going to happen. They were negotiating with their landlord. They're still there, or they didn't leave during the COVID period. There could be a distinction with respect to that if the tenant stayed in the space. And then the other piece is obviously this is a restaurant, right? So very clearly fits within the law. There are a number of other businesses that maybe you could call them retail, maybe you don't call them retail. Maybe they're in some way more closely aligned to a personal care type of business, like a barber shop or nail salon, but the landlord would make the opposite argument. So there are a number of distinctions possible out there, but for this particular type of factual situation, a pretty good ruling for tenants amidst a sea of somewhat bad rulings for tenants over the course of the last 6 to 8 months. The interesting thing is, though, we weren't sure whether tenants that were in arrears prior to COVID, whether they would be able to benefit from this provision at all, because
Right.
The landlord could argue the event of default occurred prior to COVID.
If you have any questions about this or any other topic, please feel free to reach out. Yeah, thanks.